Good morning. This is the regular scheduled meeting of the Collection Service Board. Good to see everyone here in the flesh. I think we'll just go ahead, if it's okay with you, we'll go ahead and get started. Let's go ahead and start with roll call then. Josh Holden, Greg Swirsky, Chip Hellman,
Here.
Jason Hill,
Here.
Tony Zikovich.
Here.
All right, great. Gentlemen, we won't have to do a roll call vote today with any of the action items since everyone's here in person. We'll just do a voice vote. That's a little unusual since the last year or so we've been doing electronic meetings. So as a result, we do the roll call vote. But today we'll just do a voice vote. All right, for the agenda. Does the agenda comport with what's your understanding of today's events will be? Is there any edits or any sort of adjustments you'd like to make in the agenda? I mean, moving thing around? Okay. We'll just accept a motion to accept the agenda as written. Do we have a motion?
So moved.
All right. Thank you, sir. Do we have a second?
Second.
Got a second from Tony Zikovich. All right. All in favor, please say aye.
Aye.
All right. Now to the April minutes. Those will be on your iPads there in front of you as well. Are there any edits or anything or any comments as regards to the April minutes?
No comments. I move we approve the minutes.
Have a second?
I second.
Second from Jason. All in favor, please say aye.
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 All right. All right, on to the director's report. The budget's just for informational purposes only. Of course, I'll pause and give you a chance to take a look at that for just a moment and get there. And once there, I'll go over some of the high points, and then give you an opportunity to ask any questions you have in regards to that. All right, so we're primarily looking at February through July. At our last meeting in April, we covered all the months this fiscal year through January. So we've completed the fiscal year. Its end is June, and then so you'll have the next statement you have there is what we have of this fiscal year, which is July. So February through July. The increase in technology expenses under Edison expenses in February was the only item that I saw that looked a little bit outside the ordinary. If you go to February, and then in the expenses portion of our budget, you'll look at technology. That's the second line down from Edison expenses. And February did seem to be a little bit larger than usual. Right there under technology, and with our low revenue, that put us in the red. But that was dispersed across all the programs. So that was the only thing that I saw, and of course, being a one-time expense through the fiscal year accounted for that deficit for that month. Other than that, we're trending in surplus throughout. We ended last fiscal year with a surplus of $120,000. So that is a surplus. That's quite a bit more. $91,000. I was looking at the line item above it. So $91,000 in surplus. That's pretty significant. We'll continue to monitor that, and if we get to a point where we have to do fee decreases, of course we'll consider that. That's always an option. But that's where we're headed right now. So we're looking pretty good there. If you go to the next fiscal year, the last month of record is July. And we're looking at a surplus there of a little over $9,000. So far so good. Everything's trending where it's supposed to. Nothing outside the ordinary that I can see. Is there anything that you saw when you were looking at the budget that you had questions about or would like to discuss further?
Just to clarify, you're saying that $1,293 or the technology, that's an allocation from the state?
That's correct. And
it's not necessarily a direct expense. It's just an allocation that we take our pro rata.
It's our portion of the cost. That's great. It's not a regular cost. Like for example, we share floor space with other boards as well, and so those are going to get dispersed across the rest of the boards and administrative cost backs. If there's technology enhancements to, like for example, someone's sharing a printer. We all share one printer. There's also core. If there's enhancements to core, then our board will pick up our share of the expenses, and that's based on accounting's plan, also number of licensees as well, and number of complaints. So obviously our portion is going to be significantly less compared to like Cosmo and Barber, who has 60,000 licensees and quite a few more complaints. So,
Okay, thank you.
yes, sir.
And then just the other point here is our reserve balance continues to be very healthy. And do you have any sense for at what point we're going to have to address that balance and maybe adjust fees?
We typically, when we have our sunset hearings, that's all. The legislators dig into our funds. That's something that they're going to look at. Obviously, they want to make sure we're either trending healthy and that we're self-sufficient as required by law. And in this case, if we're doing above that, then they have those conversations. There's typically a breaking point where you start discussing fee decreases.
Right.
And as we approach that, typically it's they want at least 2 times your operating budget in reserves, and then north of that, they want a little bit of room also for litigation should that occur. And for upcoming technology, we have to sort of factor that in as well. We have to foresee where we're going, what those expenses could be. And then if we're in a threshold, once we hit that threshold, if we're in excess of that, then that's usually a discussion then about fee decreases.
Okay, thank you.
Yes, sir. All right. Other questions in regards to the budget? Nothing that we have to vote on. Just that's just informational purposes only. And of course, if you have questions as you look at throughout the upcoming weeks or days ahead, or you can just email me direct, and we can have that discussion as well, and I can unpack a little bit more of that if you need to. All right, meeting dates. I'll let you get there. All right, try to keep the pattern that we've kept for years prior. So that'll be I believe the second Wednesday of those respective months, same time. Is there any questions, concerns about those dates? No? Okay. I will just entertain a motion then to accept those dates. Do we have a motion?
I accept the dates.
Right. Got a motion from Jason Hill.
Motion
Second.
accept, sorry.
I'll second.
You got a second from Chip Hellman. All in favor, please say aye.
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 All right. Application review. All right. There was one administrative item I wanted to discuss with you gentlemen. It's in regard to our application reviews. Periodically, we'll have things sort of pop up, and I just need your input in regards to how you would like to handle those things that would exceed our authority necessarily, or sometimes just your advice and counsel as to how we should approach things. Not everything's just so simple and clean cut. So we bring those things to you, and we appreciate that you lend us your expertise in that regard. Back in August 14, 2019, the board did vote to approve one of these applications or applicants where they didn't have set financials. A startup. They're not going to have set financials. In those cases, typically they'll present projected financials substantiated by a business plan, and prepared by a CPA, as that's required by our statute as well, that are consistent with solvency and our rules. Administration is requesting the authority to review those applications with the same criteria applied to other agencies that have actual financials. Of course, we'll run anything that we have incomplete information by the board, should the board choose to grant that, to make that determination. The 2019, we do have a precedent for that. The board itself advised us that if they have a business plan prepared by a CPA that shows solvency with those projected revenues, that at that point that they voted to approve that. So I'm asking the board so that we can not delay those applications, if the administration could do that. Otherwise, they're waiting about 4 months, 3 to 4 months to have those reviewed. And I just welcome your comments or any concerns or questions you would have in regards to that.
So I want to make sure I understand what you're asking for here. in the case of a startup company, they don't have a history to look back on.
Right, correct.
So all we have is pro forma data, which could be anything except that because we require a CPA to sign off on those, we know there's some level of legitimacy and not just Chip Wright, typing up a pro forma for some idea he has. So you're asking, instead of the board having to review each of those, which I wouldn't say they're rare, but they're not very many of them, that we authorize you to go ahead administratively and just do that because we've set the precedent. We've made our decision on how we're going to handle startups. And instead of going through a public vote, just authorize you.
Correct. And if you wanted that information, we could, of course, send that to you. But they're after the fact, if you chose to do that, it would go through the same review process. Bob and our other auditor as well. They're going to look at the financial, and they have to meet the same standard as the statute. And it couldn't be just sort of projected out of nowhere. It would have to be substantiated with actual backing.
Sure.
The same kind of business plan that you would take to a bank to get that sort of funding. That's the kind of meat that we're looking at. We're not looking at just sort of a business plan, but business plan in its truest sense, the type of thing that they would put together that they would to get that backing. And then we want to see that backing. So they would have to also be solvent and have those supports lined up.
So it's my opinion, since we've already decided how we're going to handle those special circumstances, that we authorize you to do that administratively and not bring it back to the board. But I'm certainly open to conversation.
And just for your reference too, if you wanted to look at that precedent, August 14, 2019 was when that decision was made, and then the board decided that so long as the financial backing and projected revenue via the business plan was established, then they voted in favor of that.
And to be clear, I mean, this is a statement of the obvious, but just to be clear, there are other things that have to be in place. For example, the bond, which continues to pop up on the legal report. And so they have to do all those things just like any other licensee.
Correct.
And
all
so,
of it.
yeah. Go ahead, guys. I just wanted to clarify.
I think that's fine. I'm okay with that.
And then upon renewal of their license, obviously, they will have to provide documentation, actual
Correct.
documentation as far as
Correct.
pro forma projections. Yeah, I'm comfortable.
Need a motion
We'll just
from
need a
us?
motion and the motion would be that administration will be able to approve those startups with a business plan. So with the fact that they're keeping all the laws and rules and all the other requirements of the application, just in lieu of actual finances, they have the pro forma and the business plan signed by a CPA for startups only. And this is the only second one we've had since 2019. So they're not racing through. We're not getting a ton of those. If we were to get more of those and we have any questions, of course, we're going to continue to bring those to the board as well.
So really our desire here is to make sure people follow the laws and the rules, but we're trying to enable businesses and not adversely harm them by causing delays. So I would make a motion that the motion you just described, but specifically that we allow that to be done administratively and not come before the board in those circumstances.
Thank you, sir. We have a motion from Chip Hellman. Do we have a second in that regard?
And I second the motion.
A second from Mr. Hill. All in favor, please say aye.
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 Any opposed? All right, hearing none, that's passed. We'll move on then to the legal report.
Alrighty. Today's legal report, there's a total of 28 cases, one of which is a represent. I believe this legal report was sent to y'all over the weekend, so just let me know if you have any questions.
Gentlemen, it's okay to say no if you haven't had a chance to review the legal report, in which case we will stop for a few minutes and allow you to look through it. If you've had a chance to review it, let me know that as well.
Typically, we can take what we've done in the past and is to also just take your questions first, because sometimes you'll dial in on one or two that sort of speak to you. And that way you're not waiting on us to get there. So if there's a question that you had about a particular one that was of more concern to you than the other, then we can do that. I'll pause, let you have a chance to sort of dig in there. And then if you just sort of nod and acknowledge that you're ready to have those discussions, then we'll move on from there, okay? Everyone ready? Okay. We'll entertain your questions first then. Does anyone have a question about any of the particulars there?
I do. I want to first start with the general problem or issue that continues to come back up on the legal report, and that is licensees who do not get their bonds renewed. And so I know you guys administratively contact them and you encourage them or warn them that they have to have a bond. In most cases, they go out and they get the bond, and then the case is closed, and that's fine. However, I look at number 8 on the list here. This complaint was opened by a member of the board's full-time staff. You guys received a notice of cancellation from the bond issuer. A respondent was contacted multiple times. They told you guys they would renew the bond, but as of right now, we've not received an updated bond.
Good catch on that one. That was the one we did update on your iPad. The one I sent you did not have the last line included, which was respondent has since provided updated bond information. So good catch on that.
So that's why it's closed.
Yeah, yes, sir.
Okay.
Yeah, we just failed to update that on the one that I sent you folks. So my apologies in that regard, but that's since been updated.
Okay. Number 13, just I want to make sure I understand what your recommendation here is. We had a complaint. The respondent provided adequate documentation for the core complaint, if you will. Shouldn't use that word here because we have a core that is a system, but the original complaint, they dealt with that just fine, but then we realized that the respondent had an expired license. And so your recommendation is that we give them a letter of warning, give them 30 days to get properly licensed, and if not, we're going to hit them with a $250. We're going to fine them $250. Or is that correct?
I'll yield to Hugh Cross. Of course, this being his legal report, I don't want to intervene any further. But Hugh.
Yep, that's correct.
Is $250 really enough when I guess it feels awful low for somebody who's operating without? At what point are we? How much longer do we go before we give them a cease and desist order or whatever? Because they're conducting business really, I would say, unlawfully or whatever, without a license, without a valid license. Is this something we're going to see if they don't comply, that by the time we meet again, you will have taken more harsh action? $250 is not likely to get too many people's attention. Okay. So you're comfortable that we're staying consistent with what we've always done in the past, and that there's a way to accelerate this? I think about all the companies who are doing everything by the rules. Here's somebody out here sending letters, making phone calls without a license. And I would say the sooner the better to get that, corrected.
And correct me if I'm wrong, Hugh, but there's the cease and desist language in the agreed citations that we send to them in those orders. So,
Okay.
Yeah, there's a form letter that goes out.
We're putting them on notice. We want them to stop their actions. Okay. I just want to look at case to be back into the. So at this point, the respondent has provided everything's been done, and you're ready to close this. Is that what you're asking for, Hugh?
Do it. Okay. Originally, this respondent, it came to me as an administrative issue in the sense that there was that these folks were not licensed, and this was under one name, but in our system that we use in the department, it's called CORE. They're actually conducting collection activity through a properly licensed entity, which I didn't know until did a sort of a deep dive into CORE but like later on when I was compiling the legal report, and I had to request the respondent to provide additional documentation to clarify what was going on there, and everything they submitted to me. Essentially, they were operating under a licensed entity, so there's a non-issue there.
Okay, can I ask a follow-up question on that?
Yes, sir.
So if a company, was it a DBA?
It was.
Okay.
Mm-hmm.
So in the state of Tennessee, if a collection company is licensed, but sometimes for marketing purposes or by service lines, they operate as a DBA, and so you're saying that's permitted under the original license?
This case was a passive entity, so it's a passive. So they're basically, you have an umbrella like a corporation or an entity, and then they have a licensed collection agency that is actually doing the work for them, and that's permitted under Tennessee law. That's correct. Yep.
Right. Thank you.
Welcome.
Any other questions? Okay.
Those are all my questions.
Gentlemen, unless there's any more, what Hugh has done historically in the past is just read the case numbers into the record with his recommendations, and then unless there's any variations that the board would like to take on those recommendations, then we just vote at the very end in one big total lump sum. Hugh?
All righty. Case number 1, 2021-020651, recommendation close. Case number 2, 2021-022551, recommendation close. Case number 3, 2021-022631, recommendation close. Case number 4, 2021-031081, recommendation close. Case number 5, 2021-031251, recommendation close. Case number 6, 2021-031091, recommendation close. Case number 7, 2021-028341, recommendation close. Case number 8, 2021-031071, recommendation close. Case number 9, 2021-036981, recommendation close. Case number 10, 2021-039471, recommendation close. Case number 11, 2021-043411, recommendation close. Case number 12, 2021-045081, recommendation close. Case number 13, 2021-041321, Recommendation, letter of warning if proof of a renewed license is provided within 30 days. Otherwise, consent order with a $250 civil penalty, proof of license renewal, and authorization for formal hearing for violation of TCA 6220-105A, unlicensed activity, expired license. Case number 14, 2021-040451, recommendation close. Case number 15, 2021-046991, recommendation close. Case number 16, 2021-040831, recommendation close. Case number 17, 2021-046141, recommendation close. Case number 18, 2021-047691, recommendation close. Case number 19, 2021-050431, recommendation close. Case number 20, 2021-050451, recommendation close. Case number 21, 2021-045551, recommendation, letter of instruction to respondent that includes complainant's current contact information to expedite resolution between the parties. Case number 22, 2021-050441, recommendation close. Case number 23, 2021-047331, recommendation close. Case number 24, 2021-051271, recommendation close. Case number 25, 2021-05284, recommendation close. Can you give me? Yeah, we just need to go back and for case number 25, just to make the complaint number correct on the record. It should be 2021-0524-52841. Case number, the recommendation there is close. Case number 26, 2021-057171, recommendation close. Case number 27, 2021-056191, recommendation close. And there's one case to be represented. Case number 28, 2020-089861. The initial recommendation was a consent order for $250 and authorization for formal hearing for violation of TCA 6220-105A, unlicensed activity. Based on the new information, the new recommendation is closed. And that concludes the legal report.
All right, unless there's any recommendation or modifications or edits in that regard, I believe we're ready to entertain a motion to approve the legal report with those recommendations. Do we have such a motion?
I move we
All right.
accept this report with the recommendations.
Thank you, Mr. Hellman. Do we have a second?
I second.
Thank you, Mr. Zikovich. All in favor, please say aye.
Aye.
Any opposed? All right, hearing none, I think we're ready for the rule amendments and law updates.
Alrighty. Everyone should have a copy of the proposed rules. I've got a drafted red line here, and these red lines are fairly straightforward, but they were prompted by the passage of Public Chapter number 549, which does a few things for the collections laws in particular. There were some deletions here which required a change in the rules. So solicitor cards are no longer going to be required. Normally we have branch offices under a primary office, and that was a statutory requirement. That the requirement for branch offices to be registered has also been removed. So that's going to remove the fees. That's going to remove the renewal fees there, and I think that's everything that this chapter touched on that required a rule change. There was also a change in this public chapter that the board generally sends, we're required by statute to send complaints to respondents via certified mail, and that is no longer going to be required. The board will be allowed to send complaints via first-class mail. However, that wasn't a rule, so it didn't require a rule change.
we will need to vote on this one because it is a rules change. But this is a cleanup to get us in line with state law. That public chapter is already effective October 1st. So, and this is just a cleanup to follow to get everything back in line and syncing up.
Okay, I move we accept these rule changes.
All right, thank you, Mr. Hellman. We got a motion from Mr. Hellman. Do we have a second?
A second.
Got a second from Mr. Hill. All in favor, please say aye.
Aye.
Any opposed? All right. We'll get that taken care of.
you.
It is a matter of policy to do a rulemaking hearing now. So even though it's a cleanup, and really there's little that, at this point anyone could do to make that alteration, but we still want to give an opportunity to the public to have that forum. So so we'll do that at the next meeting. That'll be January 12th, and we'll schedule a rulemaking hearing and go through that process as well then.
Okay.
That's all I have, unless anyone has any questions for me. That's it. Thank you.
All right, thank you, gentlemen. I think we're ready for a new business. We're super efficient this morning. So, all right, new business. Is there anything that you would like to discuss or that you would like to bring before the board?
I have one item that I'm having trouble getting clarity around. And I received a call. I'm not sure if this is the right forum for this, but I'll throw it out here, and then if it's something we take up later, talk about outside of this meeting, we can. But we had on the legal report. Excuse me, let me go back. But there was one item where the complainant alleged that the respondent had added fees to a debt, and we know, and you've cited in here, the rules of this board don't allow that unless there is an underlying contract that calls for the additional fees to be added. So, said another way, is that it is allowed if there is a contract that supports it. Is that, first off, I want to make sure I understand.
Dived into it. I remember a couple meetings ago, sort of,
Right.
Broached the topic then. Hugh, do you recall where we landed on that one? I don't have it in front of me.
I don't have it in front of me either. The rules basically say that, even if it's contrary, if you have an underlying agreement that allow for these collection fees, they still can't be arbitrary. They can't just be random fees.
Right.
And I think that's sort of where it falls. If you got certain fees, like I said, I don't have this in front of me, but as I recall, the statute and the rules are more focused on just random fees being added. If they're in the contract and they're just arbitrary fees, I don't think they would be allowed. But I'd probably have to see that on a case by case basis if that makes any sense.
Okay. So that's great. Thank you for the clarification. And I was in that meeting, and I remember us talking about it, and so all that seems right to me. Here's the specific question I was asked that I couldn't answer, and that is, certain court clerks in the state of Tennessee, all court clerks are owed fees, fines, and costs, and they come to a collection agency as a judgment. I guess at whatever point you don't pay your traffic citation or your probation fees, or I don't even know what all is in there. By statute, there's a judgment that's received by the clerk, and so it becomes kind of a legal account of sorts, but they're given to collection agencies across the state, and the collection agencies, because in their understanding they come as judgments, then there are certain things that are not really needed in their eyes, such as you can go straight to a garnishment because you have a judgment. Well, I would argue back that they still have to give the validation notice and so forth. But that's a whole nother subject. The question specifically was, some of the clerks want the collection fees added to those accounts. And are they allowed to add those, or is the collection agency in violation by collecting fees. There's really no underlying contract or credit agreement, I guess is what I'm saying. But it is a judgment by the court clerk for fees they are owed. So have we ever dealt with that in the past, or do you have any guidance? I mean, I didn't know how to answer,
So I don't have the statutes in front of me, but there's some statutes in there that refer to judgments and actual court costs. I think that would be outside the jurisdiction of this board anyway. So if they're adding judgment costs and things like that, that's something that would be taken up with the court.
Okay.
I mean, that would be my guess. I could look into it further and get back to you, but yeah, that I know that a judgment can set in place of a contract, so it's probably going to overrule a contract anyway. But then also, if it's a judgment and they're adding fees, it's not going to be arbitrary. I mean, that's going to be rendered from a judgment. It's not something the collection agency is just randomly adding for no reason.
Okay.
They're adding it because it's based from a judgment from a court of law, and that's sort of my overhead look of it anyway.
Okay, that helps. Okay. And so, therefore, whatever those costs might be, they could vary from jurisdiction to jurisdiction because we have 90 some or whatever counties, and that could be different in each county.
Yeah, I think they would have to be. I mean, unless there's some sort of uniform statute or something that would that would somehow tell the courts sort of what their fees are going to be. I mean, I think courts operate independently, so their fees are going to vary. That makes sense to me. It wouldn't make a lot of sense to me if all the court costs were the same. I mean, I would.
No, they vary from county to county.
Okay.
But I think, Hugh, what you said is my final answer, and that is it's not in the jurisdiction, under the jurisdiction of the Collection Service Board, and you should get legal advice from your attorneys.
Well, I mean, without doing sort of a deep dive into it, that would be that's my initial thought. Because when complaints come through here and there's a judgment involved, I mean, we can't really get involved with judgments.
Right.
I mean, it's not something we have any authority over. And even if the board had authority over it, it's
judgment sort of is a judge's ruling on something that essentially kind of trumps what we can do here. And I noticed on the legal report where those matters we're talking about adding whatever or something that went on in the courts, we've closed it because it's really out of our jurisdiction.
Yes, sir.
Okay, good. I like that answer because that gets me an answer, and it gets us out of it. So
okay. Well, let me know if you need anything else.
Okay. Thank you.
If you have questions throughout, I don't want you to feel like you have to wait till January either. If you ever wanted to reach out to the board direct and just send us an inquiry, we can. And of course, any times, as you know, being on the board, folks will reach out to you as well because for all purposes, you are the board. And so
right.
You're the face of the board and the board, and so they'll reach out to you. But I don't want you to feel like you're on that island by yourself. So anytime you need to reach out to administration, please do so. Okay.
But just so happened that when I got this call, I said, well, next week we have a board meeting. I'll ask the question. So
that was perfectly timed.
Yeah, it was.
Yeah.
Thank you.
All right. Thank you, gentlemen. All right. Is there any other new business? Okay. I think we can entertain a motion to adjourn then. Do we have such a motion?
Jason, you want to make that motion?
All right.
I motion we adjourn.
All right. Thank you, Mr. Hill. Do we have a second?
Tony?
I second.
All right. There we go. All in favor?
Aye.
All right. Thank you. We are adjourned. Thank you, gentlemen.
Thank you.